Good morning, afternoon, or evening. Your video is about to start. I wanted to remind you of our newer Wednesday, 1 p.m. live stream Q&A on all things Social Security. Visitors are welcome to post a question in the chat, and I'll do my best to answer it. It's on a first come, first serve basis, so please get there on time. Otherwise, if you care to be a member and get some different kinds of perks, feel free to click the join button below or just click it to learn about them. Anyway, I hope to see you Wednesday. If not, enjoy the video. Bye now. Good morning. I just wanted to share something only because it just occurred and I think it could be a really helpful thing to consider. Whether you're pro se and it may or may not be complicated, if you don't practice in this area and you're just dealing it for the first time yourself, or a newer practitioner who it might be able to help. Okay, so imagine the scenario, an under 50s person, say in their, mid 40s, becomes, according to them, and my opinion as well, disabled in 2018 due to a plethora of overlapping conditions. We could talk about autoimmune and migraines and frequent migraines, bedridden type of migraines. Um, Maybe some trigeminal neuralgia, which is that it's a little bit on the migraine side, but it's a facial pain. Those of you who have had it, I understand it's excruciating. Um, but see, an overlapping of a variety of things, including musculoskeletal issues. Autoimmune affects all the joints, strength, weakness, fatigue, et cetera, et cetera. Some anemia going on, abnormal uterine bleeding, perhaps, et cetera. So, person gets denied at hearing, and this is, say, in 2023. And the case had been started in 2019, maybe the year after the work stopped, after a crisis of sorts, and then just going through the time period until the hearing, and then denied at hearing. So one appeals for appeals counsel sometimes. Now the person's DLI, remember, if they stopped working in 18, for many people, that will mean that the DLI, date last insured, is 12/31 of 23, 5 years. Now, it's not for everybody. It depends on whether you were a robust, consistent worker for a few years before you stopped. But for many people, because most people are, that would be their DLI. So the hearing is before the DLI, a good 10 months before the date last insured. Decision comes out shortly thereafter as a denial. Appeals counsel is appealed to, during which time, and I say this a lot, continue, if you're going to be appealing to appeals counsel, make sure, and if you have a DLI window like I just described, like hearing ended, February of 2023, DLI is not till end of 2023. You have that window to continue treating really robustly for everything you possibly can, particularly the significant things that are limiting, that really impact your day-to-day activities or your joints or what have you. The things that would affect the ability to do a variety of different jobs. So fast forward, appeals counsel does indeed remand for another hearing. And the new hearing now is in 2025. Yes, that's how long the appeals counsel can take. The appeals counsel probably took a year, and then it was about another year to get to ALJ hearing by the time, the wind of it came through, which means it is getting a little long in the tooth. But one thing to look at, and this is what we did, because you have, an ALJ who had a hearing, made a decision, and now you're trying to get them to reverse it. And mind you, the person is still under 50. Um, you have a DLI problem, right? Because now at the new hearing, they're not even insured. So you have to prove that they became disabled before that DLI. In this case, as I mentioned, the person had a gap after the ALJ denial to the DLI, date less insured, where that evidence can really be used. And in this case, that's what we did. you know, read every little sentence in the next, 1,500 pages of medicals on top of the 1,500 from before. Anything newly diagnosed, um, or and interestingly, sometimes an MDI will not be found if the judge does not see that the suspected disorder has been confirmed as a diagnosis. So sometimes doctors, and this was really appalling here, for 3 years, a person's treated for an autoimmune, but the same cut and paste of so-and-so autoimmune, not confirmed yet, inflammatory connective tissue type thing. Not confirmed, but treating her with blah, blah, blah for the last 3 years. Right. So you're not going to confirm it, but you're treating her. Like, it's so inappropriate, I think. But and at the time of the first hearing, this was not a confirmed diagnosis, although the treatment and the symptoms were screaming, right? So one thing we aimed to do in the second brief for this latest hearing was point out the things that are different from the first time, still in the DLI, right? To point out that this happened before the DLI, and they were specifically pointed out it was not an MDI before because there was no affirmative diagnoses. And then subsequently, there was rhetoric about now that so-and-so has been confirmed as a diagnosis right in the medical records. And that happened, say, within weeks after the first ALJ decision. Another thing that can happen is did the treatment of something else that's significant, but the ALJ wasn't taking it as fully disabling, let's say migraines. Has the treatment for migraines changed? Did the person start going on Botox? I always look to see if that happens, because if Botox is approved by insurance, it's pretty persuasive that there is like 15 bad days a month, migraine days a month, because insurance doesn't want to pay for Botox. I guess it's not cheap. Nobody really wants to go for it either. Who wants needles stuck in their head? But that was another thing that happened right before the DLI, like 2 weeks, the first Botox injection. So it confirmed that the migraines were far more severe, although I thought the evidence was pretty strong otherwise. But this is almost more objective, right? Because the insurance company believes it, and they'd be balking at paying for Botox if they could get away with it. So pointing out things like that, the things that happened after the first ALJ decision, before the DLI, if you're blessed enough to have one that happened after your ALJ decision. And that sometimes depends on whether you filed fast, or waited years or whatever after you became disabled to actually file. But in this case, despite the longevity of the case, and we've been together about almost 5 years now, despite that longevity and the hurdles we had to, appeal and then have another hearing and all that, but it sufficed to show the judge that regardless if you want to overturn what you did before or make a different decision for that time period, which it's true that it wasn't as serious back in 1819, like, it wasn't as robust. So in this case, this under 50-year-old, when we pointed out all the things that went on while she was still insured for SSD, but wasn't available to the ALJ before because they occurred after, like the diagnoses and the change in treatment for more severe migraines, that kind of thing. It can, I think, be persuasive, number one. It also can give a little boost, I think, to the decision to award an under 50 person that, they have a hard time awarding them, because you're not asking the ALJ necessarily to overturn everything you did and, blah, blah, blah. But giving them a way to award without ever having to bend over and say, yes, the person was disabled at a time when I said they weren't before. Of course, the repercussions are you're not going to get all those back benefits. But honestly, if you're under 50, it's a really steep burden. So sometimes you got to take that bird in the hand instead of leaving the two in the bush, right? So this was uh, the idea going into it, because the person was under 50 in particular and very severely impaired. But when you're under 50, that is still a mountain of, I don't want to say you got to have a stroke of good luck, but you almost do. Um, so these are just a couple of the ways we decided to present it, like show what's changed, give that ALJ, put it right out there in the brief. This is what changed that, after your opinion and what you saw, look at, there's more now that, so no one has to, you don't have to be like, listen, you really screwed up and you didn't, like you ignored evidence. None of that. Don't have to do that. Now you can take the strong way like that, but I don't know that there's a purpose to it because it's very easy to get a denial on an under 50 who's not quadriplegic, you know? So you have to use everything you have. And I think also maybe showing the ALJ the subsequent stuff and be willing to amend that onset date when you're under 50, simply because it is such a steep mountain of evidence to prove, given what seems to be an internal policy of the SSA, um, when it comes to under 50s. And, you know, how do you prove that someone can't do sedentary work? Well, I think it's kind of obvious if they're in bed all day, but no one seems to buy it at the SSA. I mean, they just don't go with it. It just doesn't seem to be a leading, even though you see it talked about all the time, and you as a practitioner or yourself, if you're a pro se, know how much you have to be in bed, you know. Um, but anyway, I hope I'm making it clear. So if you have evidence after your ALJ decision, but before a DLI, if the DLI is an issue, if the DLI was before your ALJ decision, this isn't going to work. And we did have the backdrop of an SSI claim if all else failed, but you always want your person to get Social Security whenever possible. It preserves the retirement for Social Security. It gets them Medicare. They don't have to be under that thumb of someone controlling your every move that you are with SSI. So there is always that. Um, Getting that evidence of different, much worse things that occurred after the ALJ decision can be a nicely productive thing to share respectfully with the ALJ you're going back to after you appealed their denial. And the AC agreed with you. So, call it diplomacy, perhaps. Perhaps it's just manners. I don't know, but I like to give as much as I can to my ALJ to get them to want to award my person so that, you know what I mean? And I know that sounds weird, but, put out the best stuff you have to help persuade them that they should and they want to award your client. That's how I look at it, guys. Anyway, it was a winner of a day. I'm so excited. I get so excited. I get excited with all of my cases, um, but particularly the ones that were, you know, so difficult, under 50, those tend to be our long haulers, just because of the nature of the rules, but it worked out really, really well. So I just wanted to share that method that we use to make it very as palatable as possible to get her an award with her Title II SSD, as opposed to just, well, now that she's about to turn 50, we'll give her the SSI. That's the person worked for their SSD, didn't work for the SSI, and the SSI comes with all those rules. Not that it's not a great saving net, when we have nothing else, but if there's ever SSD for my person, that's what I always want to fight for. Even if it means going to the appeals council and spending 5 years together. Okay. Anyway, so it was a good day, and I think, a very good strategy to consider if you find yourself in that same boat. And by the way, if your DLI is way far away, it still works because your DLI is way far away. But showing them what happened after they made a denial, so you're not so much saying, you screwed up, blah, blah, blah. And you made a bad end decision. You don't have to necessarily do that. And you might have to make those concessions like, all right, let's change the alleged onset date to when this newer evidence cropped up. Okay. Anyway, talk to you later. Bye, guys. Have a great week.